The defense moved for a mistrial this morning in the trial of Sean Diddy Combs. Here's what happened. An arson investigator from the LAFD, who responded to the January 2012 auto fire in Scott Mescudi, aka rapper Kid Cudi's driveway, took the stand. He told the jury, "In my opinion, it was targeted." Investigator Lance Jimenez said a bottle, cloth, lighter, and liquid from the Molotov cocktail were sent for testing. The liquid, he testified, came back as gasoline, and partial DNA of a female was found on the bottle. Jimenez testified that Mescudi had someone take fingerprints at his home after a break-in that had occurred the previous month in December 2011. 2 fingerprints, he testified, were on the glass front door. Those fingerprint cards, though, were destroyed in August of 2012, he said, and Jimenez explained he did not authorize that. Someone within the LAPD did. When prosecutors asked, "Did that strike you as unusual?" the defense objected. Prosecutors then asked, "In your 15 years as an arson investigator, has evidence been ordered destroyed by someone not on your team?" Another objection by the defense. With the jury out of the room, defense attorneys alleged prosecutorial misconduct, arguing there's no way to unring this bell, alleging prosecutors were trying to plant an idea that Mr. Combs was responsible for the destruction of those fingerprints. They wanted a mistrial. So prosecutors then argued back. They pointed out the court previously ruled the defense could pursue questions during cross-examination about DNA and why certain steps were taken and why others were not, to try and undermine the credibility of the investigation, showing critical evidence was destroyed. The judge denied the motion for the mistrial, saying jurors were already instructed not to take questions from attorneys as evidence and that there was no testimony from the witness about those questions. When the jury came back in the courtroom, here is what the judge told them. Quote, "Members of the jury, you heard some testimony about fingerprint cards, and I'm now instructing you the questions regarding the fingerprint cards and the answers given are irrelevant to this case and the defendant and are not to be considered."